Good morning and welcome back to B for TV, your daily dose of industry information. Today's episode is focusing on the topic of time bars. It's something that we covered in great detail in October's edition of B for Link, and we're joined by Robert Windsor to give us an overview. So, Robert, thank you so much for joining us this morning.
It's okay.
So, when we're looking at the topic of time bars, what exactly do we mean?
Right. I've actually written this down because it's a legal
Okay.
definition. Um, Basically, a time bar is a contractual provision or a legal rule that sets a strict deadline for a party, that's a party to the contract, to take a specific action, such as submitting a claim or notice or fulfilling a legal case. Um, so that's it in the strictest definition.
Mhm.
It's important that this is followed, and there's actually been a recent legal case about
Yeah.
this. And if you remember, last year we did encourage members to think about an additional revenue stream
Mhm.
of actually making insurance available to their
Yes.
client. The flip side of that coin is that you have to understand how to um, handle an insurance claim. We actually have got guidance on that on our website.
Yes.
But one of the things, and it has been brought into highlight by a recent court case about the time bar,
Mhm.
and actually it was a very large insurance claim, and it
Yeah.
tends to be that sort of stuff. And the court, it was actually went to the UK courts, and the High Court and the Supreme Court both ruled that the time bar was effective in the circumstances. There can be different circumstances, but you work on the basic principle, keep to the time frames defined.
Yeah, of course.
Okay.
So, when we're looking at members handling claims, what are the kind of key things that they need to be aware of?
I think the first thing is the time bar and the limits of liability.
Mhm.
Um, there is an article in B for Link, and we look at this in a bit more detail. Um, and basically, these are the time frames for handling and getting your claims in from the main conventions. And I think we have to be aware there's two elements to this. The first is to get the claim in to the carrier, or maybe another freight forwarder,
Yeah.
if they're carrying it on your behalf, within the stipulated
Mhm.
timeframes. The second is we are dealing with liability. We're not dealing with insurance. And each one of these international conventions does um, detail the level of compensation that will be paid by the carrier's liability.
Mhm.
Um, the CMR is perhaps the most complex, um, because it's very much more geared towards the interest of the customer.
Yeah.
I mean, in one situation, if negligence is actually proven, you could actually have a claim 3 years after the event, which is
Right.
some
Okay.
time,
Yeah.
but you'd have to prove negligence. Hague Visby is the main one for sea. We have to remember 80% of all cargo is moved by sea, and that's the 2 SDR a kilo.
Yeah.
Now, that 2 SDR a kilo, because it is the dominant mode, that is reflected in the B for
Yes.
STC. You have to be careful of this one, because if you put on your bill of lading one container,
Mhm.
that's all you're going to get.
Yeah.
If you put 250 cartons packed in container number, then we revert to that.
Mhm.
You'll notice, obviously, that the last two, the Montreal and Warsaw, they are air and they are much higher levels of
Yeah.
liability, and that is reflective of the higher value per kilo of the goods being carried under those
Mhm.
modes. What you have to remember with any liability claim is you have to establish that the carrier was liable at the time
Yeah.
that the incident happened.
Mhm.
That means you've got to look at your audit trail, you've got to get your documents and all of that sort of stuff.
Mhm. So we've looked at these conventions, and I know you briefly mentioned the B for STC. So
Yeah.
what are the time periods in those?
Time period in BFA is 14 days.
Mhm.
Okay, to make the initial from the client to make the initial claim to us. So that's the first thing. The limit of liability is 2 SDR a kilo.
Yeah.
unless it had been agreed mutually and written into the agreement between the BEFA member and the client,
Hmm.
that this was to be uplifted. If you do that, you have to tell your insurance broker.
Right. Okay. Yeah.
And some people do
Hmm.
uplift it for particular clients and business. The important thing that we do put in the B for STCs is that the member can charge for this additional liability because they've got a cost, so that
Yeah.
can be passed on. Um, so it's 14 days for the customer to bring the claim to the B for member. There are then absolute time bars
Hmm.
for how long um, before suit, and that's legal
Yeah.
process has started. And the basic is 9 months from
Hmm.
the event happening. We did alter the STCs this year,
Yeah.
or rather 31st of
Hmm.
December this year, and that is to reflect those cases where it would not be practical or possible for the client to know
Right. Okay.
that
Yeah.
there was an issue. And this could reflect something like um, post-entry demand from customs, or in certain cases, if you put goods into a customs bonded warehouse, a full customs warehouse, because you can't unpack freight in that
Yeah.
situation. So it's 6 months from basically the client in those cases becoming aware that there's a problem. Um, and that really sums up the situation.
So when we're looking at kind of the things that our members need to do, what are the key actions that they need to take on this?
Well, I think the first of all, to make sure that they're aware of what the time frames are to
Yeah.
bring claims, and there are two elements to that. There's the initial claim and the longer time frame from when legal process has to be started. They should be aware of what their liability is,
Yeah.
and we always tell members if you're trading under CMR, make sure your insurer is aware because that 8.33 is a lot higher than the
Yeah.
standard. Um, and also, it's got some trickier variations, as I indicated. Time frame to start a legal action could be 3 years.
Hmm.
So the insurer needs to be aware of that. So the guidance is make yourself sure you're aware of this. I actually found all sorts of international conventions, like the American Rail Network
Right. Okay.
one. And I thought there's no point going through, but these are the main ones.
Hmm.
So understand these, understand the process that you need, and refer back to the original B for guidance on
Yeah.
insurance. So that's that. Um, and just make sure that your processes are up to date, so that you do understand this. Um, Piece of guidance, in my experience, some people would like to hold off on making a claim because they're worried it's going to affect their insurance premium. My guidance is always get the initial reserves that to the carrier, bill of lading such number, vessel, whatever, sailing date. We've been advised that there is a potential claim, and that we are going to follow this up at a later date. Just get the initial reserves and get
Yeah.
the ball rolling and establish your rights within the frameworks. Let's put it like this.
That's great. Thank you so much, Robert, for the update.
Okay, that's fine. Thank you very much for your time, Brooke.
As we said, there is an article in October's edition of Link that covers this topic in greater detail, so we'll link that in the description below, as well as the guidance that Robert mentioned. That's all for today's edition of B for TV, your daily dose of industry information.